Note, this is not legal advice and is provided for information purposes only. The topics discussed in this video apply to U.S. law only and are not a complete statement of the law. If you need legal advice, please consult with an attorney who can provide specific legal advice to meet your needs. So what's with all these claims and lawsuits involving Marvel, actors, and creators? As I believe most of you know, I am an attorney and have done both litigation and contract work in the past. Trading some text with a subscriber on the subject, I was asked to do some videos helping fans understand what may be going on in these lawsuits. Although this is not legal advice and is informational only, I agreed to take a shot. Stay tuned for the video.
Anachronic.
Hi comic book guys and gals, I'm Joe and welcome to Anachronic Comics. There's been quite a bit of news recently regarding lawsuits involving both actors suing movie companies and creators who are attempting to regain ownership of characters that they gave up under varying circumstances many years ago. Now, I've watched YouTube creators and bloggers acknowledging that they are not attorneys, bringing up issues and providing commentary which, although entertaining and at times morally satisfying, fail to consider relevant laws and the practical aspects that the parties to these controversies may consider. As I mentioned, I was asked to explain what was going on. Now, I have no crystal ball and I'm not privy to the facts or the contracts that surrounded the lawsuits. But what I can do is provide a high-level outline of some of the legal and business issues that possibly may be involved. Of course, as I mentioned, this is not legal advice. All right? It's simply informational. The disclaimer I set out in this video should be taken to heart by the viewer. First, let me say at the start that there is no such thing as comic book law. Instead, it's a hybrid of a number of laws. There have been books published on comic book related laws, and a simple search on Amazon will bring them up if you're interested. Now, during this short video series, I'm going to try to present some basic information on two areas that would apply to these lawsuits: contract law and copyright law. In this video, let's talk about contracts law. So most people have a basic understanding of contracts. We enter into them all the time. A lawn service, buying a car, taking out a loan, going to the movies or a comic book convention. We're all signing documents outlining the terms of the agreement between us and the other party. But do you read these contracts? Likely not. In its simplest form, a contract is an agreement between two parties that sets out each party's responsibilities, how long the contract will last, and the consideration, that is, the money that will exchange hands. It could be written, which sometimes is required for commercial contracts, could be verbal, or it could even be implied by someone's actions. The making of a contract requires at least two parties mutually consenting to the terms. In the law, we call this a meeting of the minds. The key is that if a contract is legally entered into, it is enforceable by law. So for a comic book creator, or an actor, or a comic book publisher or a movie studio, whatever contract is legally created will bind that entity to the terms that were agreed to. Now, most lawsuits based upon a contract allege that one party or the other breached the agreement. That is, the breaching party did not do what they promised. One good example of an allegation of a breach is the lawsuit filed in Los Angeles County Superior Court in July by Scarlett Johansson against Disney Studio involving the Black Widow movie. Now, it was recently reported that the parties settled the lawsuit on terms that, based on the reporting, both parties are happy with. Now, in the lawsuit, Ms. Johansson alleged that the studio's release of the Black Widow movie on the Disney Plus streaming service reduced the theater revenue and therefore the total net profit, which formed the basis for profit sharing in her contract with the studio. In the complaint, she argued that she was promised by Marvel Studios, which is owned by Disney, that the Black Widow movie would be a, quote, theatrical release, end quote. She said she understood this to mean a window of time would pass before the movie would be streamed. a period that traditionally has lasted for 90 days. In response, Disney said at the time that it had fully complied with her contract and that the case had no merit whatsoever. So again, I have no crystal ball, but what likely happened here? Well, the primary legal issue that the court likely would have addressed here is the meaning of the promise of a, quote, theatrical release, end quote, as agreed to by the parties. That is, what was the meeting of the minds? Although there are many legal principles to help form this inquiry, simply the court wants to know, what did the parties agree to? It's reported that Ms. Johansson indicated that she believed that they had agreed to a 90-day window between a theatrical release and putting the movie on Disney+. Disney states that they did do a full theatrical release as promised, and that there was no prohibition to putting the movie on Disney+. And, in fact, due to COVID restrictions in place for movie theaters, placing the movie on Disney Plus actually increased the net profit upon which Ms. Johansson's profit sharing was based. If the case had gone forward, the court likely would have looked at evidence of the negotiation between the parties, as well as if there was some past practice that Disney took in similar contracts. Now, normally, these types of controversies are resolved without a lawsuit being filed, unless one of the parties feel that the court needs to get involved to move things along. So here, the fact that the lawsuit was settled is not a big surprise. So why does starting a lawsuit move settlement forward? I think there are three basic reasons. First, lawsuits cost money, and settlement often is a financially prudent approach to ending a controversy. Second, few companies are willing to have a court decide what a contract term means, setting a precedent that could adversely affect not just the contract being litigated, but all the company's contracts, potentially adversely affecting its business. Although I will provide more of a detailed explanation of work for hire under copyright law in another video, in the case involving Jack Kirby's estate, it was Marvel's concern that the U.S. Supreme Court could provide a new and problematic definition of work for hire that caused the company to settle, even though it won its case in the courts below. The third reason is that companies are often concerned that bad publicity in connection with a lawsuit could hurt the company financially. In the Johansson matter, Marvel was receiving bad press regarding the way it handled all of its actors' compensation with respect to using Disney Plus releases, not just Johansson. While interestingly, Warner Brothers received good press. For example, it was reported that Warner Brothers paid Gal Gadot an additional $10 million when it issued Wonder Woman 2 on HBO Max the same day as the theatrical release. The lesson here for Johansson or any creator is not to assume that a word or phrase means something, but to make sure the contract defines a term to mean what you want it to mean. The other lawsuits going on now involve Marvel and creator ownership of a number of comic book characters, including the Steve Ditko family alleging ownership rights regarding Spider-Man and Doctor Strange. The controversy involves what is called work for hire. It's a contract or agreement, but it's primarily a copyright-based matter. I will address at a high information level creator contract and intellectual property rights in a subsequent video in this series. I hope part 1 of this series was helpful to you and helped you better understand some of the contract issues that may be involved in comic book creator and studio controversies that we have been reading about. Now, I want you to do me a favor. If you enjoy these types of comic book law videos and want to see me do more of them, let me know in the comments below. Now, don't forget the disclaimer. This video is not substitute for legal advice. It's informational only. It's a couple of people having a beer and having a discussion. So that's the video. Thanks for watching. And if you enjoyed it, please give it a thumbs up. Be well, and I'll see you soon.